Planning Commission work session of Monday, January 23rd, 2023. Do a roll call real quick.
Commissioner LaSalle.
Here. Didn't have my mic on.
Vice Chair Schlagenhofer.
Here.
Chair Stoll.
Here.
Commissioner Laws.
Here.
All right. Ms. Richter, legal training. It's all you.
Thank you, Chair Stoll, and welcome Commissioner Laws and Commissioner SP if he's watching online. Welcome to the Oregon City Planning Commission. My name is Carrie Richter. I am the Deputy City Attorney, and I am charged with providing a little bit of land use training for the next hour. And I have about 15 slides. I know some of you have seen some of these slides before, but I've tried to modify them, add to them, change them around a little bit, so hopefully everybody will get something out of my presentation today. The Oregon Land Use Planning Framework, if you want to ask questions, I welcome them as we go along or at the end. We'll try to get as far along as we can. If we don't get through everything, we'll schedule another one if it's okay with Aquila. So there's no rush, but we're going to try to get through everything in an hour. The Oregon Land Use Planning Framework is subject to another number of laws, and the first a sort of basket of laws that the Planning Commission is charged with implementing in various circumstances are the U.S. Constitution and federal laws. So these are ones that are passed in Washington, and these include, most importantly for your purposes, the Fair Housing Act and the Americans with Disabilities Act. There are state regulations that apply to the work that we do together, including the Oregon Revised Statutes. Those are the Oregon laws that are passed by the Oregon legislature, and they set forth very specific things that we have to do, most notably the procedures that we have to follow. Those are set in state law and implemented on the local level. So we don't have a lot of flexibility about the long speech that Chair Stoll has to read at the beginning. That is all set by state law. We can't change it or make it more exciting, even though we might like to. Administrative rules, there are state agencies, most notably the Department of Land Conservation and Development promulgates rules that then local governments have to implement. So that's another set of rules that we have an obligation to follow. The regional level, we've got Metro setting rules, including the urban growth boundary, and then they have the management functional plan that tells us how we have to plan to develop areas that are within the urban growth boundary. Then we implement most of those requirements within our city land use regulations, and those take the form of the Oregon City Municipal Code, the Oregon City Comprehensive Plan, the Oregon City Zoning Map, and the Oregon City Comprehensive Plan. And so we'll talk a little bit about each of those, but that is the framework, and the way it works is one builds upon the other, and so we are implementing, so we don't have to evaluate every provision of the Constitution when we evaluate an application, because we have implemented the obligations of the Fair Housing Act and the takings clause, for example, in the code. So the code says we have to make decisions that are roughly proportional. That implements the Fifth Amendment. So that's why we don't have to go through every Oregon Revised Statute provision when we implement the code, because when we amend the code, we make determinations consistent with state law. So that's the framework. 20 days ago marked the 50th anniversary of Oregon Republican Governor Tom McCall's remarkable speech to the opening of the 1973 legislature, when he issued his clarion call to end sagebrush subdivisions, coastal condominium, and the ravenous rampage of the suburbia of the Willamette Valley. And, I want to share with you some of his speech because I think it is so famous and it sets the framework for how the Oregon land use system was born. Oregon is an inspiration. Whether you come to it or are born to it, you are entranced by our state's beauty, the opportunity she affords, and the independent spirit of her citizens. You and I shouldn't claim we love Oregon more than anyone else, but that we love Oregon as much as anyone. Our thoughts today and our deliberations to come must spring from our determination to keep Oregon lovable and to make it even more livable. As stout defenders of the environment, Oregonians have provided all appropriate safeguards except one. The gravest threat to the environment and the whole quality of life lies in the unfettered despoiling of the land. I mean, I feel like I'm at a poetry reading. The interests of Oregon for today and in the future must be protected from the grasping wastrels of the land. We must respect another truism that unlimited and unregulated growth leads inexorably to a lowered quality of life. So 6 months later, the Oregon legislature adopts Senate Bill 100, and that's the statewide framework for the zoning regulations that we know today. And that is what required an urban growth boundary and where we were going to protect the farmland and we were going to keep urban development within, condensed in our urban areas. So the Senate Bill 100 required that the Department of Land Conservation and Development implement statewide land use goals, and they have done that. And the statewide land use goals require that local governments adopt comprehensive plans, and it says what general principles have to be implemented in the comprehensive plan, and that includes things like citizen involvement, includes managing urban growth, includes economic development, includes housing, includes transportation, it includes natural and historic resource protection, but in a large part, how a local government does that is up to the local government. It says that the local government has to do these things, has to go through certain steps, certain procedures to inventory things and project growth and housing needs and job needs, but it doesn't say you have to have this many jobs or this many houses. So local governments have a fair amount of discretion to decide how it's going to provide housing, how it's going to provide job, what kind of jobs it wants to further based on its own needs. So it's quite visionary, and Oregon was one of the first states in the nation to have a statewide land use program that is principled on this idea of urban growth management, protecting farmland, and letting local governments implement these 18 values set forth in the goals the way they felt was necessary. So the long-range planning example I want to talk about is OC 2040, which I believe is in the soon-to-be adopted phase. Adopted now phase. I have it right here. You gave it to me earlier. And
it's adopted and printed and on the website.
And bound and in your probably library at home. So anyway, the OC 2040 comprehensive plan implements the statewide land use goals, right? It is the long-range planning document for Oregon City, and it explains what sort of goals and policies are going to drive decision-making in the city. And it includes transportation system plan, it includes utility master plans, it includes procedures that govern how decisions will be made. And then from there, the comprehensive plan is implemented in the Oregon City Municipal Code.
And Commissioner LaSalle, you have a question?
Has that gone to the next level of state government it has to go to?
It has been adopted by the City Commission, and I'm assuming it was sent to the Department of Land Conservation Development, what we call acknowledgement. So I believe that's happened.
Yes, it has happened, yeah.
So it has been what we call acknowledged. When something is acknowledged, that means the statewide land use goals no longer apply to decisions that require application of the comprehensive plan. So let's think about highly discretionary decisions like conditional use permits, where the comprehensive plan would apply. The comprehensive plan will apply and not the statewide land use goals. There are 4 types of decision. Commissioner West.
Would it ever be, what would be the circumstance that it would, the state would rule over the comp plan, or are there any?
If there was a new law that had not been implemented in the comprehensive plan, if there was a new goal, let's say there was talk sometime about a new goal, goal 19, that would be climate change. If there was a new goal that the city hadn't implemented in its comprehensive plan, that goal would apply to land use decisions directly.
Okay, thank
Until you get it in your plan, it applies. So when some of the middle housing stuff that you all adopted regulations for, the concern was the city had to get on that. If it didn't get on it, then the rule was going to apply directly.
Okay, the state rule, yep.
Okay, so there are 4 types of land use review categories set forth in the zoning code. And these categories are are distinguishable by the level of discretion necessary to take the action. So if a person files an application for a site plan review for a single-family residential house, and Christina has to decide if the house is set back enough to meet the code, and it is the right height, and it has the right square footage, and it has the right window transparency, Christina has no discretion to decide that that there's variability in what a 10-foot setback is measured at. So those are called administrative decisions, and those are type 1 decisions, meaning they're over-the-counter permits. You come in, bring your plans, Christina checks the boxes and signs the form, and you have your permit. Those are over-the-counter. There is no appeal right. There is no notice. There is no formal evaluation. It is just over-the-counter. Administrative decisions. Type 1 decisions is the label the code uses. Type 2 decisions have a little bit more discretion. Type 2 are staff decisions with an appeal right to the City Commission. Type 2 decisions are land division decisions, partitions and subdivisions, and decisions over aesthetics like site plan reviews for commercial development. And the reason why those are type 2 is because we're evaluating transportation and utility adequacy, and there's a little bit of discretion there because there may be some adjustment to a road width or where the street trees go or what where the light poles go. And because there is some exercise of discretion, we have an obligation to give notice. There is a comment period, so we give notice to the neighbors. The notice says that the city is considering an application for a land division, and you have, is it 14 days? 14 days to submit written comments, and people submit written comments, and those comments are incorporated or considered by city staff when they make the decision, and then the city staff makes the decision and mails a copy of the decision out to all the people who submitted comments, and those people have an opportunity to appeal to the City Commission. So those decisions you will not see. They don't come to the Planning Commission.
And I would just like to point out that procedure that Carrie just described is one of the things that's outlined in the state laws and the ORSs. That's when she was saying there's procedures that we can't change. That's one of them.
Those have a type of decision, it's called a limited land use decision, and the structure is set out in 197.175 of the Oregon Revised Statutes.
Greg, can I ask?
Questions?
Oh, darn it, just asking him now, the notice, how many feet, and does it hold the same for type 2, type 3, anything? How many feet around the neighbors?
How much? It's 300 feet, and
Okay.
it's the same for type 2 and type 3.
Okay, thank you.
So type 3 decisions are the discretionary decisions, right? This is what the Planning Commission sees. These are the decisions for conditional use permits, for variances, for preliminary concept plan approvals. These are where the questions of compatibility, questions of impacts, questions like that come before the Planning Commission. And these decisions where we are talking about one property, we're talking about one applicant wanting one thing, are where the Planning Commission's job is quasi-judicial. That means the Planning Commission sits like a judge and determines whether the law, in this case, the code and the comprehensive plan, whatever the code says the criteria are satisfied. So this is the judicial part of your role. And you aren't making the law, you are applying the law. You are interpreting the criteria and determining whether they're satisfied, just like a judge in a court. And so those cases include notice to neighbors within 300 feet of a public hearing. There's a public hearing where everybody gets an opportunity to testify, and there are appeal rights for those who testify to appeal to the City Commission. So it has the same appeal rights as a type 2, but there's much more broad discretion just built into the criteria. And there is no state law that says it has to be a type 2. For example, with subdivisions, the state law says it has to be a type 2. That's what the state law says. If you're reviewing things for aesthetics, it has to be a type 2. But conditional use permits, variances, concept plans, master plans, a one lot or small lot zone change, or small number of lot zone change, those are all type 3s or even type 4s, depending on the scale.
Carrie, can I
Yeah.
ask one more? So
Yeah.
was the 300 feet, is that a state law, or is that what the city has decided? That they'll send notice
That is
to?
a state law.
Oh, it is, so
It
it's all
is.
across the state, okay.
It is a state law, and there are some cities who have more expanded notice provisions than the state law provides. The state law provides a floor, so the city could decide that it wanted to give notice 1,000 feet.
Okay.
So the city could decide a bigger area. There's an interesting case about what happens if a city screws that up. In the state law, if you break a state law, you have to do it again. If you break a city procedure, there has to be somebody who's prejudiced. So it's an interesting question when you have that circumstance. But for purposes of the notice requirement, that is a floor, not a ceiling.
Okay, thank you.
Commissioner Schlagenhofer. I wanted to say chair, but sorry, it took me a minute.
It's okay. Just so we have some examples we can relate to. The Thimble Creek Concept Plan, type 4?
Type 3.
Or was that legislative? The entire concept plan?
The entire concept plan adoption was legislative because we were
Legislative.
making policy to determine whether it implemented the comprehensive plan.
Okay.
I was thinking Park Place when you asked the question. Yes, Thimble Creek concept plans are type 4.
Okay.
Type 4 is a political decision. You are making policy at
Okay.
that point.
Okay, what about the landfill development?
That was a master plan, that was type 3.
What would be a type 4? I don't think we see too many. Do we have any examples?
It would be concept plans and zone changes or code amendments.
Okay, Park Place? 3?
This was a master plan, so that was a type 3. The concept
Okay.
plan adopted it in '08 was a type 4.
Got it. Okay, thank you.
The sewer, the single lot annexation we did for the sewer a couple months ago, is that a type 4?
That's type 4.
Okay. So basically
It was
anything
type
that,
4.
anything that goes through us and ends up with the ultimate decision at the city commission is a type 4. Is that fair?
She is. So I wasn't here when you did the Thimble Creek. What differentiated that from a Park Place concept plan?
Thimble Creek, which was originally called Beaver Creek Road Concept Plan, was adopted in '08-ish, about the same time as Park Place, and then the concept plan was reopened in 2019 to make some amendments and then to do implementing code. So amending, none of my talking was on the code, sorry about that. So Park Place, concept plan, Beaver Creek Road, initially adopted in '08. In 2018-19, it came back to the Planning Commission to amend the concept plan, which is an ancillary document to the comprehensive plan, that's type 4, and then adopt some implementing code. So that was a type 4. Now, the actual master plan, like Park Place Crossing that came in this summer, was a master plan that was requesting development within the Park Place concept plan area that was already adopted.
So with the concept plan, you're making policy, right? You're deciding what this area is going to look like, right? And you have all kinds of authority to decide what the area is going to look like. Once you've adopted the concept plan, you know what the area is going to look like, and you're evaluating a discrete development proposal to see if it meets. You're evaluating it to meet the policies that you set before. So it's a different type of work. The concept plan adoption and changes to the comprehensive plan, those are, you have much more broad discretion, right? You're not subject to criteria, whereas the concept plan criteria of 1765 says, you know, a preliminary concept plan will have this and this and this and this and this, and you have to determine whether it has those things.
I should have remembered that, sorry.
No, this is why it's not obvious. The line is not bright. Okay, the reason why we have very specific type 3 decision-making procedure is in order to ensure predictability in the decision-making and a level playing field for all participants, right? We want everyone to know what the rules of the game are going to be when they walk through the door, when they want to participate, when they want to submit comments. And so the code specifies a pre-application meeting with staff and a neighborhood meeting. The code requires that the application be filed, and then state law specifies a completeness review. Completeness review is a determination of whether or not the materials have been provided to deem the application complete. That does not evaluate whether or not the criteria are satisfied. That is not the part of completeness review. Completeness review says, the code says you got to have a transportation study, and you have a transportation study. Whether that transportation study is one sentence or 500 pages, that checks the box for completeness. State law specifies that once the city deems an application complete, it has 120 days from the date of completeness to issue a final decision. A final decision is not the Planning Commission, it is after all appeals. So that's when the city has to get moving on these applications, because if the city does not make a decision within 120 days, it can be subject to litigation and circuit court. And that is all set forth in state law. I told you got mailed and posted notice. That is set forth in state law 1977.797 sub 6, and it's set forth in the code. And we have, the law is very specific about what the notice has to include. It has to include all the criteria that the staff believes are applicable to the application. It has to provide that the staff report will be available 7 days in advance of the hearing. It tells what day and time and location the hearing will be. The law changed a year or so ago and requires that we offer a Zoom alternative now, and that is all in the notice. And then at the hearing, we have to provide the legal disclosures that, are mind-numbingly boring, but that's what the state law requires, and so that's what we do. You probably all know there is, at the initial evidentiary hearing, the first hearing on the type 3 application, there is a right to a continuance. Anyone can request a right to a continuance, or what we call an open record period, which is a timeline when folks can submit materials in writing rather than come again at another hearing. So state law provides that continuance period and that open record period. And then the record is closed after all the public testimony has been heard and the Planning Commission deliberates and makes a decision. There is a right to appeal type 3 decisions, but the review in those appeals is on the record. So that means that there's no more evidence that is considered. That's why it's really important that the Planning Commission serves as the evidentiary body. So you are the receiver of all the evidence, and that's why all the records are so long, because you are the lucky folks who get to receive all of those papers. So let's talk a little bit about the players that are involved in the type 3 process.
Ms. Richter?
Yeah, please.
Before we continue, can we go back one slide? Okay. The completeness review. If an applicant submits their application, it's complete, the 120 days begins. What if they realize they made a big mistake on the traffic study and they need to amend it? Does that restart the 120?
It does not restart the 120. What happens is they submit the revised study, and the city staff would go to them and say, you have submitted a new study. We don't have time to review it. We've got a hearing coming up. Will you agree to extend the 120-day clock by a certain amount of time to allow the city staff? The applicant is the only one who controls the 120-day clock. The city cannot control. They can ask the applicant nicely to extend, but we cannot force or extend it for them. We have to just ask and hope that they will agree, because if they don't agree, then we would deny the application because we haven't had an opportunity to evaluate what they've proposed.
Okay.
So ordinarily, they work with the city to extend, because the cost of going to circuit court is not cheap and it's not fast.
No. Okay, yeah, because we've had quite a few applications where they present some new information like on the day of the meeting, and there's half an hour to, review it, so, okay. All right, thank you.
So I have a few questions here. Number one, with House Bill 2001, and obviously on my side end, I came onto the Planning Commission. I'm still a neighborhood chair on the side, obviously different than this. A few concerns that come into play is type 2, type 3. Is there any opportunity to involve the residents more in the process? Because I've talked to some developers and they'd like to have more interaction with the residents. Is there any opportunity for that, or can we implement some type of change in the future where we implement more dialogue with the residents?
The issue would be that state law requires that type 2 decisions are processed more quickly.
Okay.
So inserting a neighborhood participation piece into that might make it difficult for the city to issue its decisions fast enough.
Okay.
Is there a neighborhood meeting requirement for type 2 decisions?
For some type 2, but most type 2, but not all.
So, I mean, as I said, the state law sets the floor.
Okay.
Local governments can decide to do more, but it doesn't change the decision-making deadlines that we are subject to. And many of those type 2 decisions have to do with needed housing, and there's special clear and objective requirements in terms of the criteria that have to be applied. So the city doesn't have a lot of, the neighborhood doesn't have a lot of discretion to accept or not. So in other words, we can look into it, but there may be some limitations.
And then the next part is here. Years in the past, the neighborhood associations had a liaison that would help guide through. Obviously, we see the neighborhoods come here. We've seen the commission, planning commission, where they're just overwhelmed with the process. Is there going to be a liaison for the neighborhood associations in the future to go through this process or something to look into? Is that something the city would like in the future, or?
So I think you're referring to a past practice where there was a staff member assigned to each neighborhood association?
Or just in general one to the neighborhood associations that would be separate, obviously still part of the city, but separate from, that would be more representative of the neighborhood associations to guide them through this process.
So if you're asking about staff being that representative, that's something that we're still talking about. I know Commissioner LaSalle asked about that as well. If you're asking about like a land use chair from a neighborhood association, I would imagine that's something the neighborhood association needs to kind of rally around.
That's tough for a lot of neighborhood associations, just because a lot of residents still, they either don't get involved, or it would help the planning commission, though, I would think, if there was more of a process for the neighborhood associations to have more guidance on that. I know Christina does the best she can. Thank you very much. But anyways, and the third question, my final question here is, I know that the city attorney and land use attorney represents the city and the constituents. Who are the constituents? I'm curious. Thank you.
Are you asking who the city attorney's client is?
Right, it is the city, but what is the definition of the constituents for the city? The city represents the city and the constituents. Who are the constituents?
So I think there's a couple of parts to your question. The constituents in the general sense are the people who live here and do business here and are part of the community. But the city attorney typically does not represent those folks individually. They're representing the city as an organization. So sometimes it can be hard to kind of separate out the two different cities, right? We have the city as an organization, which you might think of like another corporation almost, and then, the city, which is our community and residents and business owners. So that the attorneys typically represent that organization and helping us navigate through the myriad of laws that you've just received a portion of the land use laws, and there's all kinds of other ones. So does that help answer the question?
I guess if we're having, for instance, a land use appeal, who are the constituents in terms of, obviously the city attorney and land use attorney are representing the city. We know that. I just want to know who the constituents would be defined as.
I'm not sure I can answer that. I guess I'm not quite following what your question is, but maybe it's something we can talk about more kind of offline so I understand where
Yeah, I'd just be curious about that in the future. Thank you. I don't want to hold anything up.
Okay, so real quickly, I think you understand
I'm sorry, I missed. Commissioner Sal has a question also.
Is there a limit on the number of continuances?
Oh, turn your microphone on.
Is there a limit on the number of continuances that can be allowed?
The state law only requires a continuance at the initial evidentiary hearing. After the initial evidentiary hearing, in other words, the second, third, fourth, fifth, there is no right to a continuance. The Planning Commission has discretion to grant a continuance, but the state law says that the city has got to issue a final decision within 120 days after an application is deemed complete. That is the absolute end to when the city has to issue a decision. So if the Planning Commission grants continuances and the meetings go on and on and on, the city will not make that 120-day deadline.
Unless the applicant
Agrees to extend.
I guess I'm confused then, because commonly, someone will ask for a continuance, and then the applicant will grant that continuance. So that would go beyond the 120 days. So my question was, those type of continuances, is there a limit on those?
There is no limit except for the 120-day limit that the applicant can extend. That is the end. So there can be as many continuances as you want, as long as the decision is made within the decision-making deadline. And you keep in mind that you are not the final decision maker, the city commission is, so we have to reverse engineer it so that we give the city commission time to hear an appeal.
So somebody will ask for a continuance, and then the applicant will agree to extend to allow time for that continuance to be granted.
To be accommodated.
Yeah, to be accommodated. Okay.
Correct. Carrie's always looking at me and says, "You've gotten the 120 continuance. What date is it?"
And it has to be in writing.
Tracking it.
And so there's always a little bit of scrambling.
We've seen it a few times, yeah.
You've seen the scrambling.
Yeah, yeah. All right, thank you.
All right, so the roles and responsibilities, real quick. So the applicant is the party that submits the application. Their job is to provide evidence that establishes that the applicable approval standards are satisfied. And what's important to know about the applicant's job is they bear the burden of proof. That means they have the obligation to come forward with evidence to convince you that the criteria are satisfied. That's why they have the experts, because they've got to have a transportation study, they've got to have a stormwater study, they've got to have a geotechnical analysis, right? They've got to bring forward the evidence that shows you that the criteria are satisfied. The planning and legal staff's role in the process is to make sure that the process complies with the law. That is our number one job, is to make sure that the process is consistent with the code and with the law, the state law, with respect to procedures. Our second most important job is to provide some recommendations about interpreting the code and to assist the Planning Commission in locating evidence, or our job is to be the experts on the record, right? And to tell you where you can find something or who submitted what, and our job is to maintain the record, right? We have to know what came in and what's out. So that's the role of the planning staff. Neighborhood groups and other participants, their job is to raise concerns, right? Their job is to ask questions. Their job is to challenge the evidence. Their job is to procure other evidence and provide their perspective, both in terms of how they believe the criteria should be interpreted. That means giving meaning to the standard, right? That's one thing. And then whether or not the evidence meets the standard. And they could either say, that transportation study is wrong because of X, Y, and Z, or they could say, I have a transportation engineer who says that that transportation study failed to evaluate this, and this, and this, right? Evidence can take different forms. So that's the neighborhood's job. And your job as the decision maker is to interpret the criteria, educate the public, and provide a public forum for these public hearings, and to evaluate the evidence and make a decision based on the applicable approval standards. And in order to do that, the law provides that you have to be impartial. And impartial decisions come with certain obligations. They carry with them certain obligations. First, all decisions, type 3 decisions, have to be based on testimony and evidence that is part of the record. That means if you have particular expertise on a particular intersection, a particular tree, professional experience in a particular area, you have an obligation to put that information on the record during the hearing so that people have an opportunity to question you about your experience and your perspective. You know, I have driven that intersection 100 times, and I know that the cars back up in this way. That is something that should be in the record if you think that that will influence your decision, right? So when Chair Stoll reads the disclosures, he's going to ask if anyone has had any ex parte contacts. Ex parte contacts in the traditional sense means conversations outside of the hearing. That means somebody walks up to the grocery store and says, Commissioner Laws, this application is a terrible application. You should deny it because it doesn't comply with this requirement. That is an ex parte conversation because it happens outside the public hearing when people who come to participate don't know what's happening. And that's what ensures transparency and openness in the process, right? Same with the applicant. The applicant can't call, you know, Chair Schlagenhofer and tell him how he ought to vote, right? That would be an ex parte contact that has to be disclosed at the beginning of the hearing. And every single time for every public hearing, we will ask, we will poll the commission to see if they've had any ex parte contacts. But ex parte contacts do not have to just be direct conversations between the public and you about a matter that's before you for consideration. Ex parte contacts can include newspaper articles that you read, blog posts that you read, next door posts that you read, and again, your own experience that you think is relevant to the discussion. All of that information needs to be disclosed at the beginning of the hearing. And if you read an article, read a blog post, have a conversation, reach out to Aquila or Christina or Pete and say, I saw this in the newspaper, what should I do? I saw this blog post, what should I do? And then we can vet it in advance and talk to you about, you know, what makes sense in terms of getting it on the record so that folks know that it's out there and that people have an opportunity to comment about it, because it's the secret, right? It's the fact that's not known that gets you into trouble. So we've had people who've received campaign contributions put those contacts on the record. Involvement with neighborhood associations, those contacts have been on the record so that the public has an opportunity to ask questions.
And conversations with staff, are those ex parte contacts?
Those are not ex parte contacts.
Even if it's, I'm reading an application and I think that the staff missed a section of code that applies, and I say, hey, I think section such and such applies.
I encourage you to ask questions and tell staff what you think in advance of a hearing so that you can, they are a sounding board to you, and those are not ex parte contacts.
Okay.
And I encourage you to do that so that you can understand and really grapple with the information. If you have questions or you don't, you think this code section applies, bring it up to staff in advance so that, and then at the hearing, you can also bring it up.
Sure.
You can say, I emailed staff and I said, I wanted to know what this was and I wasn't satisfied with the answer, I don't believe the answer, or you've said this, and so, but the more you can use staff as a resource, I encourage you to do that, because I certainly appreciate it when I know, I think, who was it? There was Chair Powell, Tim Powell, I think, used to sometimes he would write down, I think, here are my thoughts, and here are my questions, and to have those in advance allows us to prepare and be really responsive and efficient.
Nice. Commissioner Laws?
So in the past, I've, obviously been to some hearings, and, a planning commissioner will say, I went on site, I went to take a look. That would be ex parte, wouldn't it?
It would.
And then the other part would be as well, let's say, okay, so you're going up Holcomb Road. You're not going to look at the site, but you're going to go see the traffic on Holcomb Road. Would that be ex parte as well?
It would be, because you went with the purpose of collecting information that you're going to weigh against the criteria.
Okay, thank you.
But if you're sitting on Holcomb thinking about your grocery list, that wouldn't be ex parte. I've heard people say, I drive that road all the time. Well, I would imagine you all drive these roads all the time, right? But, that.
Commissioner LaSalle?
I don't know if this would be the time for this in your presentation, but can you give us some guidance on how we interact with one another outside of the meetings? Would ex parte contact apply to that, or would it be under a different set of rules?
It's a different set of rules, and it's a public meeting. A majority of you cannot get together and talk about any matter of city business without complying with the public meetings laws. That's why, aside from it being a ex parte contact, it would also be a violation of public meeting law for you all to, say, email each other about what you think about an application. The whole idea is you're a judge. Think about a judge. They don't go talk to the other judges about how they should rule, right? If they do that, then there is information passed that isn't in the courtroom setting, right? And so we want to try to avoid that if possible.
Commissioner Laws?
One other question. For instance, I'm an admin to my neighborhood site, since I'm still the neighborhood chair, and someone posts something about obviously something we're discussing with the planning commission. As a planning commissioner, obviously I would try to avoid that, right? I wouldn't look at it or try to engage with that in any way. But obviously if I'm an admin, what position would that put me in?
What I would recommend that you do is get in the habit of, when you see traffic related to an application that is before you or you think might come before you, send it to Aquila.
Okay.
And the whole idea is we just put it in the record.
Okay.
We just put it in the record, and then everybody can read it.
Okay.
Right? And then everybody knows that it's been submitted. That's just really the safest course, because if somebody were to say you read it, even if it was just a caption, right? You really like the person who sent it, and you read, and the caption was, "This is a terrible application." We wouldn't want someone to challenge your impartiality over this, right? So the safest course is just to get it in. And whenever I read, the Clackamas Review, and I see articles or editorials, I put them in the record. Like you probably have seen, we'll put them in editorials, because it's safer for them to just be in the record. Then everybody can know what is out there for public consumption.
So question then for you. The folks that post those, do they have an expectation of privacy? Is it a private group where they would expect what they post doesn't make it into the public record?
No, everything should be public for people who belong to that group, but it may not be for people outside that group. So, but still, I would, based on the instruction, would definitely say, I saw this, screenshot it, send it to Aquila.
Yeah, I'm just wondering if somebody would have posted something and then it ended up in the public record of the meeting, they'd be like, I did not mean for that to happen. That's a question for you. That's just a thought.
Yeah,
I don't know how the group's set up. But.
It's something to be concerned about, so I really appreciate the guidance.
But we'll, if you send it to Aquila, we can take a look at that, sort of privacy issue and make sure that we are communicating with that person. And, I mean, we can work that out. But it's far better for you, it's a safer spot for you to just pass it on and let Aquila and our office make those calls than it is for you to decide on your own.
Sounds good.
And Vice Chair Schlagenover?
Yeah, I got a quick one. I know we're running out of time. So we're not supposed to speak to other commissioners. Okay, if we have if we have more than half the commission, that's considered a public meeting. But one-on-one, let's say there's something in a traffic report that says the intersection has had no accidents in the last 2 years. But then you remember, well, shoot, I was just talking to Greg the other day, and he says there's an accident every second week. Would that be ex parte contact? Is that something we're supposed to forget to do?
I don't think that is an ex parte contact, but I would disclose it.
Okay, but it's not a public meeting.
Because both of you, since you have talked about it, are thinking that there was an accident every week because you've learned that. And the public ought to get a chance to question or explain why your understanding of an accident every week shouldn't apply, or it should apply, or how you misinterpreted the question,
Yeah.
That kind of stuff, that kind of information comes up a lot, right? Where you don't expect the hearing to go in that direction, but it does go in a direction of something you know something about, right? I know about that historic building. I know about how water treatment works. I know about this storm, containment pond. I know, and as soon as that comes up, you should say, I know something about that. My understanding of that thing is this. And then it's out there, and it's in the public record, and everyone has an opportunity to question you or clarify any of your understanding about that. Because I think oftentimes you all live in this community. Of course you have feelings about it. Of course you see things. You're not expected to have blinders on when these applications come up. Of course you drive down Holcomb. Of course you drive on 213. Of course you do. That's why you are a planning commissioner, right? So the law acknowledges that you have opinions and you have knowledge, but it asks that you put it on the record so that folks can participate.
Okay. But it'd be considered ex parte, one person talking to one person wouldn't be a meeting?
No,
Okay.
It won't be a meeting. A meeting is when you have a quorum.
Okay. All right, thank you.
All right, decision makers must be free of actual bias. Actual bias means that you cannot make a decision based on the criteria. You are too close to it, and we all have biases. We all do. There are things that I could not decide on because I feel too passionately about it to make a decision based on the criteria. And it is not a failure to have a bias. It is everybody has them. And when you feel you are biased, you cannot participate in the decision. And it is okay, and if an application comes before you that you feel you cannot set aside your personal feelings because it's in your neighborhood, because it is your friend, because you've always hated that thing, then that's why we have so many of you. We can afford to lose a few. you know? I'm teasing. We love to have all of you participate, but we understand that there may be times when it's just too close. And in those cases, please just reach out to Aquila or the staff person who's working on the application, and I don't want to participate in this one. And that, no more questions asked. Conflicts of interest. You cannot have any financial interest in an outcome. And that is a hard and fast state law, and there's very specific rules about it. So if there is a chance that your son mows the grass for that applicant, reach out to us and we can talk you through whether or not that is a conflict of interest and, you know, how we can deal with that. Conflict of interest cannot be disclosed away. You can't, you know, say, I won't let the fact that my son needs this job affect the outcome. If you have a conflict of interest, you can't participate.
I want to do a quick time check since I think we're at the end of this slide.
Yep.
And we've got about, I think we're only about halfway through, and we're at 7 o'clock. So I'm wondering if you all want to continue this discussion to our next Planning Commission meeting. We can schedule another work session, meet an hour ahead of time.
Is continuing the discussion right now an option?
Yep, sure.
And have planning commission late?
Well, we advertised the Planning Commission meeting to start at 7, but it's the same Zoom link, and I think it's the same
I mean, the city commission
YouTube.
does it all the time.
So,
So
I know, but we're the Planning Commission.
it's a pleasure of the members.
I would propose that we continue this next time
Okay.
and do our regular meeting.
Yeah, I was going to agree with, oh, darn, I forgot your name, Chris. Commissioner Staggs. Or continue it after we do the planning commission, either one. After tonight, maybe like at 8 o'clock or whenever we finish, or next time. Next time would probably be better.
Is that an option?
I would prefer
Next time.
next time.
Yeah,
Next time,
earlier in the evening.
Yeah, we can do that. We have a meeting for next time anyway, so can we do another 6 o'clock? Okay. All right.
Sorry.
Any final words? Like, you can have a couple more minutes if you want.
No.
No? Okay. We'll pick up where we left off.
Yeah, let's, we'll pick up where we left off, which is at public meetings, so we'll kind of be sort of swimming in the same pond when we start up next time.
Okay.
Okay?
Sounds good. Thank you.
All right.
Work session is adjourned.
Thank you.